ladies and gentlemen. This book is a labor of love. It is a project that began more than 6 months ago, an endeavor that has still yet to end. It is a chronicle and a record of one of Asia's oldest professional institutions. Ladies and gentlemen, the Sri Lanka Law College is an institution unto itself. What this book tries to do is to make its contribution to our society, its continuing relevance, clearer. It does this by exploring its historical evolution from multiple perspectives. The book also raises many questions. Perhaps the most important of these is this: how do institutions become relevant to societies, the societies they inhabit? How do they become more representative of the people they serve? To answer that, however, we must go back in time. Sri Lanka's legal system predates the colonial encounter. Historical records, including stone and rock inscriptions, tell us of how our kings and rulers respected the idea of judicial autonomy. Even though it may be anachronistic to apply contemporary notions of law and order, justice and equity to our past, there is enough evidence to show that these ideals were respected, even reinforced prior to European colonialism. However, the contemporary idea and ideal of legal education is very much a colonial inheritance. Our first European colonial masters, so to speak, the Portuguese, did not bother with educating its subjects, our people, on anything, even on the laws that they brought with them. Their successors, the Dutch, were far more nuanced, one could say far-sighted, going to the extent of codifying customary and indigenous laws in our land. The British, pioneers of the civil service and the colonial project in more ways than one, had a very different view of the matter. They continued with efforts at applying and codifying indigenous and customary laws, but they were driven by an almost fanatical zeal to ensure deference to their institutions, including their laws and customs. The 19th century British experiment of nurturing a narrow circle of elites committed to European customs, manners, habits, and prejudices thus found a pivot in Sri Lanka, or Ceylon. In Sri Lanka, British officials found an elite quite willing to yield to them, despite the occasional insurrection or uprising against their rule. It is against this backdrop that we must chart the history and trajectory of the Sri Lanka Law College. When, in 1874, the Council of Legal Education was founded, a flourishing middle class, reformist if not radical in their outlook, had sprung up in the country. This middle class was conservative and nationalist to varying degrees. Some preferred to cooperate with the colonial administration, others vied for reform. Almost all of them were content with their country falling within the orbit of British imperialism. The colonial middle class, however, sought ways of maintaining their position and prestige, sometimes in opposition to colonial rule. In the last quarter of the 19th century, the professions held a certain appeal for this class. Medicine and law in particular seemed to promise affluence, if not status. As the sociologist Ralph Peels would much later write,
in Ceylon, specialization was limited by the narrow range of career opportunities of a limited kind. The lowest in terms of status being that of graduate teacher, the highest the prestigious civil service.
In other words, a gradation between, on the one hand, the graduate teacher and on the other hand, the civil service. Between the graduate teacher and the civil service, the Ceylonese had much to choose from, depending on their station in life. The middle class lacked the advantages of wealth that the colonial bourgeoisie or elite did. Yet they were animated by the same social aspirations. In the late 19th century, only medicine, and to a greater degree law, could square the circle and resolve this paradox. Lawyers formed an influential group in Ceylon well into the 20th century. The Council of Legal Education, the sole body responsible for the admission of and regulation of lawyers, produced some of the most reformist and also some of the most conservative faces of colonial society. Their intervention in the context of the struggle for independence cannot be ignored. To give just one random example, when the first political party to call for complete independence from the British, the Lanka Samaja Party, was formed in 1935, it counted among its first batch, so to speak, a doctor and a lawyer, S.A. Vikramasinghe and Colvin R. De Silva. Today, ladies and gentlemen, things have changed dramatically. Right after or before independence, I can't remember the exact year, Sri Lanka's first cabinet minister for education, Eddie Nugavela, made some remarks about the social composition amongst the students at his school, Royal College. Nugavela remarked that since C.W.W. Kannangara's reforms, the Royal College is no more a school for the rich and privileged classes. Observing that 317 of 519 parents there worked as peons, laborers, chauffeurs, and so on, he concluded that the school had opened its gates to the lower middle class. Ladies and gentlemen, it is transformations like these that have made institutions in Sri Lanka more representative, inclusive, and relevant than they ever were. The challenge today is to maintain standards, ethics, and benchmarks while opening these institutions to as many communities as they can. This is not something we can stop, it is something we must accept. This book, in its own humble way, attempts to grapple with these questions. It is not meant as a final word on the subject, but rather an attempt that must be followed by many others. When we began research for this book several months ago, we did not know where to start and where to end. Fortunately for us, we had a team of supervisors, coordinators, and veterans from various fields. We were constantly frustrated in our attempts to fill in blanks, and on more than one occasion felt downright discouraged. Yet despite these setbacks, we have been able to bring our project to a satisfactory close. Ladies and gentlemen, this is an institution that has withstood the test of time. It is currently going through a major bout of reform. One can only hope that as it forges ahead, it remains mindful of its essential task, ensuring a legal profession that is closer to, representative of, inclusive of, and accountable to its people. We demand accountability from our politicians and elected officials. I cannot imagine why we should not do the same with our professionals and professions. Institutions too, particularly those dedicated to higher education, have a massive task ahead of them. If they are to thrive, they must be open to collaboration. They must be open to cooperation. They mustn't be territorial in the extreme sense of that word. Even though we see a tendency among certain sections of our professions to claim credit for oneself without sharing them with others, this cannot be an attitude that Sri Lanka can have if we are to forge ahead. Ultimately, it is that hope which resides in this book. On behalf of Factor, which headed the research and compilation for this book, and on behalf of everyone who was part and parcel of this publication, I would like to thank all those who contributed to our project. Thank you.